So thanks very much, everyone, for your patience. And now I think we are ready to begin again with this part of the event with the technical issues solved. I think I failed to introduce myself. I'm Lisa Donner. I'm the Director of Americans for Financial Reform. And again, thank you to all of our panelists and to all of you for being here. So Marcus Stanley, who's AFR's Policy Director, is going to moderate this panel. And our eminent speakers include Simon Johnson, who's the Ronald Kurtz Professor of Entrepreneurship at the MIT Sloan School of Management, and fills many important advisory roles, including probably most related to today's conversation, as a member of the FDIC Systemic Resolution Advisory Committee. And I, at least, and I think many in this room, are extremely grateful for all the ways that his incisive and eloquent analysis has advanced the policy debate about financial regulation and financial reform in so many different ways. Bruce Grosel is a Helen S. Balick Visiting Professor in Business Bankruptcy Law at the Delaware Law School. He spent many years in private practice, representing debtors, creditors, committees, and trustees in Chapter 11 bankruptcy cases and litigation, and we were very lucky to enjoy his company as a senior fellow at Americans for Financial Reform for a while, a few years ago. Stephen Lowen holds the Harvey Washington Wiley Chair in Corporate Governance and Business Ethics at Seton Hall, and is an expert on corporate finance and governance, corporate restructuring, financial distress, and debt. And he's also both the author of a leading corporate finance textbook for those who want the extremely dry version, and a regular columnist for the New York Times Deal Book page. So accessible to many audiences. I'm very much looking forward to the discussion. So one last logistical thing is that we're going to ask, when we get to the questions, we'll ask Marcus to repeat the questions perhaps, because we are trying to film and we want to hear what the conversation sounds like.
Okay, thank you. I am not only going to moderate the panel, but I'm going to start off by giving what for some of you will be a very much a review of a few of the very broad framing issues involved with resolution. But I think it's useful to go through some of these issues just because there's often, sometimes I think, a deliberate conflation of some of these issues. And some of them are, I think, very important in putting what is a very complex and detailed debate in perspective. So I know I see a couple of experts in this room, and my apologies to those of you for whom this is review, but I'm going to go through three issues quickly. One is Title I versus Title II of Dodd-Frank. They're both about Section 165D is about orderly resolution, and Title II is about orderly resolution. But then there's some very important differences between them, and I think that issues from Title II often get carried over into Title I, sometimes deliberately, in ways that are deceptive. Then I'm going to address two key questions about orderly resolution that apply to both Title I and Title II, and then I'm going to talk about the primary jargon words that you encounter in this space, which is single point of entry versus multiple point of entry resolution. That's a very technical debate, but actually brings you to some really important conceptual issues about whether we can make this thing work. So Title I, Section 165D of Dodd-Frank, requires that, as Lisa said in her introduction, that banks demonstrate through their own resolution plans that they can achieve an orderly resolution through conventional bankruptcy. And regulators either have to certify that they have successfully done that or take steps to downsize or reorganize them so they can. And if you, like me, and I think like a lot of other people, are very skeptical about the ability of the top 6 mega banks to truly use conventional bankruptcy for an orderly resolution, then you can read this as saying just regulators are required to downsize the big banks, which is why people are so excited about this issue, because this is a very powerful mandate, because this is a very difficult task that's been given to the banks. Now, in Title II, of course, we have an entire title of Dodd-Frank, a very long title, that gives the FDIC receivership powers to achieve an orderly resolution, is supported by a public liquidity financing mechanism, and relies on FDIC authority rather than the bank's own plans. And so the key differences here, right, are a receivership authority, which is governed by the rules in Title II versus a conventional bankruptcy, and a public financing mechanism that could run to hundreds of billions of dollars in public credit, is in Title II, but not in Title I. So when I said that people deliberately conflate these titles, boy, it would be really nice if you could come in and you were a big bank and you could say, I can be resolved, I can get an orderly resolution through Title II, where I have this hundreds of billions of dollars in credit potentially available to me, and therefore it's credible that I can do an orderly resolution and just kind of slide over the conventional bankruptcy part. And I actually do hear where a conventional bankruptcy without public support. And I do hear that in the public debate. The regulators are not exactly going to fall for it, but it is an issue that gets blurred, I think. And a lot of the planning that's gone into Title II is also relevant to Title I. So the two key questions here, I think, first is order, and these apply to both conventional bankruptcy and Title II. First, is orderly resolution even possible? And you could think about that. What makes a resolution orderly? Limited economic spillover to third parties, no taxpayer costs, a true liquidation or restructuring of failing banks, so that we don't have zombie banks where the fundamental problem that led to bankruptcy is still present. And the barriers to orderly resolution, these have been discussed quite a bit. So and they're going to be discussed more by our panelists, but they're the size of these banks, the complexities of these banks in terms of their international operations and internal organization, and the need for financing sources that are scaled to bank size. Now, the second key question, which I think is much more complex and does not get talked about as much, but I think is really a critical question, is when we come up with a resolution mechanism, is this mechanism in some sense a disguised bailout? So what if it's a mechanism that involves substantial public support that isn't paid back? What if our mechanism doesn't truly restructure the bank? What if it just wipes out some bondholders and then lets the bank continue as it was? What if the costs of the orderly resolution fall on innocent parties or people who weren't really insiders making the decisions that drove the failure of the bank? And then the last issue, single point of entry versus multiple point of entry. In single point of entry is a resolution technique in which the resolution powers are applied directly only to the top level holding company in the bank. And subsidiaries below the holding company continue to operate, but they're recapitalized by wiping out the long-term debt that's held by that holding company. And they're transferred to a new entity. So we have a new name for the bank, and we have bonds converted to capital, but the bank after single point of entry resolution might look very much like the bank before single point of entry resolution. And the advantages that people talk about with single point of entry is that it appears more feasible, especially in the Title II context where you have a liquidity line of public support for that. Because it addresses a lot of the problems with potential conflicts between international laws. And supposedly we're going to keep these subsidiaries operating. And I think the problem or issue people raise with single point of entry is the chance of that disguised bailout I talked about seems to be significantly greater. We may end up with a situation where the creditors of the subsidiaries, think of AIG Financial Products, think of the people who were buying derivatives from AIG Financial Products. Those people were not bondholders at the holding company level. They were creditors of the subsidiary because they had purchased derivatives. They might not have borne any of the costs in a single point of entry resolution of AIG. We might not get that restructuring. We might end up with a zombie bank that still has significant difficulties but is continuing to operate and hasn't truly been downsized or restructured. And the multiple point of entry approach allows you to go in and resolve single or multiple subsidiaries directly. So you can really restructure the bank using this approach if you make it work. You may take out individual subsidiaries where the problem is, sell those subsidiaries, just shut them down. And I think the advantages of a multiple point of entry approach are that some of those disguised bailout issues aren't as significant, but the disadvantage is that people question its feasibility. because you've got subsidiaries operating in multiple different jurisdictions. You've got the internal complexities of these banks can make it very, very difficult to have firewalls or divisions between different subsidiaries so that you can separate one subsidiary from another. And multiple points of entry, I think, is much more demanding in terms of structural reform of the banks. So those are just some framing comments, and now I'll give it over to Stephen Lubin to address some of these issues in more detail, in particular conventional bankruptcy versus other forms of resolution.
All right, so I just have a few very perky slides. Here is the basic idea, and Marcus started to talk about this, right? In single point of entry, whether applied in Title II or in a conventional bankruptcy, the goal is going to be a two-step process where first of all you try to recapitalize the operating companies, and then you file the holding company for either OLA or for bankruptcy under the normal approach. So that's the basic setup. How exactly do you recapitalize the subsidiaries? Well, here's the answer from the public portion of Goldman Sachs' plan. A lot of text there that I'm going to highlight in a second, but in the nutshell version is you basically are going to fund liquidity or put liquidity down to the subsidiaries. You're going to possibly put capital into the subsidiaries. You're going to possibly forgive intercompany loans between the parent and the subsidiary. So there'll be a big transfer of value down to the subsidiaries, and then the parent company will file for bankruptcy if we're talking about the sort of living wills version of this approach. Now, here's the issue, right? In basic bankruptcy law provides that a insolvent company can't give away its assets and it can't sell its assets for less than reasonably equivalent value. These are both called fraudulent transfers or fraudulent conveyances, depending on which state you're in. So if we then go back to the Goldman Sachs plan, there's a lot of things in here that look very much like fraudulent transfers or fraudulent conveyances, and they're all supposed to happen the day before you file for bankruptcy, which is like, you know, even a first-year bankruptcy student could figure out that there's a problem with this, right, on the final exam. What's going to happen then, right, is that if you do file, say, the Goldman Sachs holding company for bankruptcy the next day, all the bondholders of that holding company are going to say, hey, they committed a fraudulent transfer. Let's go sue the subsidiary who received all this money or all this value. And then you will have a giant lawsuit against the very subsidiary that presumably you wanted to recapitalize that was causing the problem. Now, this is not exactly a blinding insight here. I mean, any bankruptcy attorney could tell you that this problem exists with all of the publicly available resolution plans. The only one that comes close to talking about this is the Bank of America plan, and even there they hint at it in a way that's so subtle that unless you happen to be a law professor, you probably didn't even notice it. So I raise it not so much because there's this obvious problem and the regulators and everybody else have missed it. I assume that somewhere back in the thousands of pages of the non-public part of the plan, somebody must have talked about this, or at least I hope, right? That they talk about this issue, but I raise it here for a couple reasons. First of all, right, these plans are supposed to be credible. Credible to the regulators, but it seems to me they also have got to be credible to the market and to the average public who reads only the public part of the plan. So why is there no discussion of this obvious issue in the public part of the plan? That's one issue. Another issue here is I think this highlights a broader problem with just assuming what you can do in Title II, you can also do in bankruptcy. It's not necessarily the case. You can't just sort of take whatever you've developed in the regulatory context, in the context of a resolution process that's going to be totally within the control of the FDIC, and just assume you can apply that to a process that's going to be in front of a bankruptcy judge with a bunch of creditors who have standing, it's a court case, and they have standing and ability to bring lawsuits and all this kind of stuff. So that's the other big issue, is just that ability to transfer to the other context, right? And so it highlights the problems. What exactly is going on with this resolution process if the publicly available plans contain, a violation of what I'm calling Bankruptcy 101? And are they really credible? So in the interest of time, I will save my other comments, actually, I think, for the questions, and we'll let Bruce go on.
Thank you. My name is Bruce Groskow. I practiced bankruptcy law for more than 25 years. Before that, I did a lot of commercial transactions work. So I come to the perspective of funding a bankruptcy plan from the practice of law and from having to find money in a bankruptcy case to pay the bills once the case filed. There are a couple of terms that I'm going to get out of the way early, and a couple of events. Most companies commence a bankruptcy proceeding by the simple act of filing a bankruptcy petition. That automatically imposes an automatic stay that keeps creditors from going after the debtor and going after most of the debtor's assets. The term debtor in possession applies to a Chapter 11 case where the officers and directors of that company continue to operate it, make all of the major decisions in the bankruptcy case, as well as the decisions regarding the operations of the company. And the term debtor in possession is shortened to DIP, D-I-P, and when people refer to post-bankruptcy financing or post-petition financing, the jargon is usually just to call it DIP financing. So you'll see that in the slides. That's what I'm talking about when I talk about post-petition or DIP, or those terms. The filing of the case creates a stay and does a lot of things for debtor. It does not create funding. There's no magic a loan that shows up. There's no magic use of money or anything like that. Most companies don't generate sufficient cash to fund their operations and their restructuring once they file the bankruptcy case. And most of them need to borrow money, just as you would borrow outside of bankruptcy, from a lender. And that lender is called a DIP lender. In a large case, it would be a consortium of lenders, the same way in a large commercial, with a large company outside of bankruptcy. One of the first issues, though, in a bankruptcy of a bank or of a large bank is the sheer scale of what we're talking about. The largest banks, as Senator Brown mentioned in his opening remarks, are huge institutions now. I updated this recently. I don't remember the source, but I have it in my notes somewhere. The biggest banks are around $2 trillion, and the GDP of the United States is, I would defer to Professor Johnson, I think 27 trillion now or something. So it's only 17. So we're talking, this is asset value, obviously, but these are huge institutions. The idea of borrowing enough to fund both their operations and their restructuring is a daunting task, I believe, especially when we compare the largest DIP loan facilities on record, the largest bankruptcy loans that have been made, which cap off at about $10 billion for Calpine. Lehman only borrowed about $500 million, only, and that was just to fund the loan to own that Barclays Bank went through in buying the core operation of Lehman. So it's not simply that one shows up in court and says, hey, approve the money. The debtor files a motion called the DIP financing motion. The bankruptcy code is very good at emergency relief, so the good news is a bankruptcy judge can approve interim financing on the first or second day after the company files, but only to the extent necessary to avoid immediate and irreparable harm pending the final hearing, which is at least 2 weeks later. The DIP loan can be unsecured, but almost always a DIP lender will require collateral as well as super priority claims and other things I won't go into. But here's a key piece. A DIP loan, the post-petition bankruptcy loan, cannot obtain lien priority over existing financing unless the collateral position of that existing financing is protected. So if the loan is for $10 billion and there's a $10 billion loan in place, if the new $10 billion loan is going to go ahead of that existing $10 billion loan, that first lender has to be given $10 billion or new collateral worth $10 billion or something to keep it in the same place in terms of the lien priority and the distribution of proceeds that would follow if the collateral was liquidated. And that's very daunting when, that's a very difficult task when there are not sufficient assets on hand. So the problem then is how does a resolution plan under Title I of Dodd-Frank, and how do the regulators together provide for the wherewithal for a large bank to borrow money post-petition, which it's going to have to do. And the trend seems to be toward keeping the bank holding company's collateral, for the most part, unencumbered. And that seems to be the key to how this might happen. If it's a single point of entry approach, and that bank holding company is filed finally, and if the transfers that Professor Lubin spoke about are going to be challenged as fraudulent transfers, which I think they would be, then the bank holding company has to have some collateral that it can then give to someone to borrow the money on a post-petition basis. Most of the bank holding company's collateral would consist of the shares in its subsidiaries. And there are, these institutions have thousands of subsidiaries. But if the bank holding company granted a lien in those shares in the subsidiaries pre-petition, we'd have the problem of not being able to borrow money and not being able to prime that lien. And the collateral wouldn't be worth enough to borrow against. Lots of bankruptcies in the modern world in lots of bankruptcies in the modern world, the existing financing is called undersecured financing, which is that the collateral has eroded to the point where it's worth less than the loan. In a normal commercial bankruptcy, the lender is very willing to lend into that situation post-petition because it's preserving its collateral value, and it can protect itself best by lending because the going concern value of the company is kept and is maintained. It's a little different, I think, in a bank bankruptcy because the financing is different and because there are fewer automatic stays. The automatic stay affects fewer of the assets. For example, repo lending is not subject to the automatic stay, and the repo lenders can simply take their collateral. Secondly, a bank holding company might have been forced in the spiral into bankruptcy to guarantee things like the derivatives book of its subsidiaries and pledge the shares pledge these shares in support of that guarantee. In addition, the secured party just might not be able to find a lender in a time of systemic stress. So it's a much different situation than in a normal bankruptcy. There are a number of things in the resolution plans that recur that are dubious resolution funding sources, and I list them on the slide. Things like a fortress consolidated balance sheet doesn't deal with the assets and liabilities of each entity. Asset sales take time, and the proceeds first have to be applied against any lien against the assets. Intercompany payables in the Lehman bankruptcy, the intercompany payables between the subsidiaries, according to the disclosure statement, would take years to sort out. Some were to be allowed claims, some were recharacterizable as equity, et cetera. This was wild gotcha in a case where I think it was $1 billion in legal fees. And when they confirmed the plan, they said, we can't sort out the intercompany. So these are, I think, very dubious sources. The FDIC and the Fed about a year ago listed where the main common problems were in the resolution plans. Marcus referred to it. The complexity of the structure is a huge problem. And really the focus was developing a holding company structure that supports resolvability and extending the stay to apply to certain kinds of collateral more than the law provides now, both on an industry-wide and a firm-specific basis. Ultimately, what can be done is, I think, minimal or no secured debt against the equity in the subsidiaries. Held by the bank holding company. Limits on cross-collateralizations, cross-defaults, and downstream secured guarantees by the bank holding company, and more extensive stay protection. The ultimate question is not just are these institutions too big to fail, but maybe they're too big to file. Maybe they're just too big to go through a normal bankruptcy. I think that unless some of these changes are made to these resolution plans, that they won't be successful and won't be able to rapidly and orderly resolve themselves in a Chapter 11 bankruptcy case. Thank you.
How long, Marcus?
10 minutes matters. I'm trying to speak into the mic.
Yeah.
Hi, my name is Simon Johnson. I'm not a lawyer. I'm an economist. I'm the former chief economist of the International Monetary Fund, and I'm currently a professor at MIT Sloan School of Management. So I think the question before us is quite straightforward. How much progress have we made with regard to Title I and Title II of Dodd-Frank, and do we need to go further? And I'm afraid that these very helpful presentations and Marcus's frame remarks at the beginning have only further convinced me that we are a very long way from solving this problem. And I'd like to say three things specifically about that. The first is Title I. Well, Title I, as has been very clearly explained already, is intended to allow any firm, any financial firm included, to go bankrupt unimpeded by any kind of government support without that causing a systemic event in the United States or internationally. And I have to say that the living wills that have been filed and all of the plans that have been put forward by the large bank holding companies are completely non-credible in this regard. And specifically, I would direct your attention to the fact that all of these companies are enormous, complex, and operate very much across borders. So you can read their own public statements. They operate in 40, 60, 80, 100 countries in various ways. Now, there is nothing, to the best of my knowledge, that would allow or require or even make possible cooperation between the various bankruptcy judges in these different jurisdictions in the event of a failure or impending failure. That's not what happened in the case of Lehman. That's what Senator Brown took us back to, September 2008. The authorities in the UK that were responsible for the liquidation or the receivership of Lehman Brothers there seized assets that arguably, people have argued, belonged to the US part of the business. That's exactly what's going to happen next time. Title I is not going to work, I can assure you, unless you force these banks to disentangle themselves internationally, to operate completely separately across borders and to fund themselves separately across borders. And that is not on anyone's agenda right now. So that's a problem. That's non-compliance with Dodd-Frank. That's a failure to implement the law. Now, the second point is, what about Title II? Now, I see Art Merton at the back, and Art and his colleagues at the FDIC have worked very long and hard on this, and I do choose my words carefully, Art, in this regard. I recognize the intention of Dodd-Frank to create a backup authority. I think that was missing in September 2008, and that was an important effort, and the FDIC has worked really hard to try and create some credible plans here. But I am very worried about where we've reached. Now, I have a lot more deep personal up-to-date experience with securities regulators and banking regulators in Europe than I am sure anyone else in this room or this building or likely within about a 5-mile radius. And I can tell you, based on that experience, that the current situation I'm speaking about today, this week, in Europe, in the European Union, in the Euro area, but also in the European Union, as a matter of law and practice, it's an absolute disaster from the point of view of the problem before us today. Right? Now, if you want to know the details, I'm happy to share the details. Some of those details will completely shock you, okay? And you will be appalled by what happens there. That there is not convergence on this. There is not going to be reasonable cooperation. There is going to be bizarre, absolutely destructive behavior by them in a crisis situation. If you are relying on the cooperation of any European authority, when the time comes to deal with the resolution of a major bank holding company based in the United States, you are going to be sadly disappointed. And you're going to be thrown back on the best efforts of the FDIC, supported by other US authorities, and I'm sure they will do their best to prevent that systemic crisis becoming worse, but they will have to commit government resources to do that one way or another, and I don't think you're going to be happy with that, and I'm afraid I don't think that's going to be interpreted as completely consistent with the spirit of Dodd-Frank. That leads me to my third point. So if Title I is dead in the water, and Title II is extremely problematic given the situation in Europe, how have we done on the preventive measures? How have we done on bank size, on bank complexity, on bank capital? Well, the reality here is there's obviously lots of complexity that's laid before you, lots of numbers, huge reports and so on. It's really very simple, and you can reduce it all to one page. And I have the one page with me here. It's a very detailed one page with a lot of writing on it, which is why I don't put it on the screen. But it's from Tom Hoenig's webpage. He's the vice chairman of the FDIC. And he calculates correctly the size and the capital levels of large banks in the United States and around the world, puts it on a comparable basis. And he emphasizes, and I completely agree with this, that what you should really look at if you want to understand loss absorbing capacity of banks is tangible equity relative to tangible assets. This is loss absorption. This is what really matters. There's a lot of other stuff that's thrown into the mix. Doesn't matter in a crisis. People talk about risk-weighted assets. Come on. The one thing you know is in a crisis, the risk weights always prove wrong. So tangible equity, tangible assets. How are we doing? Well, first of all, by the way, the size of the banks, the largest banks, is not $2 trillion. The right number to take there is, actually I take this one from the Federal Reserve Systemic Risk Reports, the FY15s. Largest bank in the company, okay, I'll name names, it's JP Morgan Chase, it's a public event. $3.8 trillion. $3.8 trillion, okay? That's the total exposure, and that's the number you get on the Honig calculation too, roughly speaking. So we're talking about close to $4 trillion. This is obviously much larger than what we had before the crisis. So the largest banks are bigger. The biggest four, the biggest six are much bigger than they were in the run-up to the crisis. Senator Brown already said that. He's absolutely right. The capital of the largest banks, on average, I'm being polite, so I'm just going to talk averages, 5%. They are funded with 5% equity, 95% debt. How were they funded before the crisis? Well, if you go backwards in time with the Honig numbers as far as you can go, they were funded with about 4% equity, 96% debt. So when people say capital has increased dramatically, there's an interesting mathematical interpretation going on there. From 4% equity to 5% equity is not dramatic in my book. It's a small increase. Yes, it's gone in the right direction. Yes, we are pushing harder. The regulators, including the FDIC, have done work on this. Not all the regulators have been entirely cooperative, sadly. But really, 5% equity in this world with these problems and the kinds of losses that we experienced in the last cycle, this is very far from creating, I think, any kind of reasonable assurance that the system is safe. So they can't file under Title I. Oh, well, Title I filing is not going to help you at all. It's off the table. It's an illusion at this point. Title II, well, I'm very worried, and I'm warning you, and I'm warning everybody who will listen. And they won't listen. And they won't listen in Europe to any reason in this regard. So then you're thrown back on what are the buffers? What are you requiring? What are the... And this is all... It's all been laid... the Brown-Kaufman, during Dodd-Frank, would have put a size cap on the largest banks. That was a good idea. We didn't do it. Brown-Vitter, been on the table for quite some time, and it's still on the table. Graduated higher capital requirements. As you become big enough to threaten the world system, you have much higher capital requirements. Great idea. Not being implemented. Let's go even further. Let's talk about as much. Let's make banking boring. Absolutely. Well, I'm open to any and all boring proposals. The more boring, the better, as the outcome. The modern Glass-Steagall that has bipartisan. These are all bipartisan ideas. Brown-Kaufman, Brown-Vitter, modern Glass-Steagall has Democrats and Republicans supporting it. What else have you got? I mean, we've made some progress. It's a small amount of progress. Some people have worked very hard, and I admire their work, and I encourage that work. But we have not made enough progress, and we've absolutely not ended, in any reasonable, plausible sense, too big to fail in this country. Thank you very much.
Okay, Simon, tell us what you really think. But seriously, that was a very good presentation, and I'm interested in knowing the appalling details about Europe, or at least those you can share. But apologies, we have some of the regulators here for our next panel, but you guys were not here. We had to start this panel a little bit late. So we are going to run about 5 minutes late on this panel in order to get the opportunity for questions. But before opening the questions to the audience, I'd like to ask one question to the panel and either speak loudly or come up and use this mic, since this is our operating mic. We heard Senator Brown say in his speech that there is the possibility of legislation for a new Chapter 14 to the Bankruptcy Code, and we got a little taste of what that legislation could look like in some legislation that was advanced by Senator Toomey last year. that would create special bankruptcy code procedures for large financial institutions. And I sort of see this as an attempt to bridge some of these gaps between between Title II resolution and bankruptcy that we talked about in these presentations. So what do you guys think that this is really feasible? Would it be helpful, and what are some of the dangers of it?
Well, maybe I'll try the speaking really loud thing and see if that works. So I testified in front of the House Financial Services. No, I think it was the Judiciary Committee, some House committee, and in favor of the House version of this bill, which notably does not include repeal of Title II. But you have to keep in mind, right? There is no funding mechanism. So some of the issues that Bruce talked about are all still relevant to this new Chapter 14. So the short answer is I think new Chapter 14 would be a useful tool in a very narrow set of cases. But without a funding tool, it will be an extremely narrow set of cases, because without outside funding, it's very hard to see how this works at all. So it might help in the future case of CIT or some sort of bankruptcy case like that in the future, make it a little smoother, but it's a very small incremental improvement.
I'd like to add something to that, which is that if Chapter 14 involves the repeal of Title II, which is the regulator's resolution authority, that will result in the following. First of all, the provisions regarding the regulator's ability to control systemic risk and minimize moral hazard are out the window too. There's nothing in the bankruptcy code that lets a bankruptcy judge hold officers and directors that brought the company to its knees accountable. And in addition, a bankruptcy judge is not given the mandate to control systemic risk. The purpose of a bankruptcy is to maximize value and maximize the prospects for reorganization of a company. What Title II of Dodd-Frank does is give the regulators the ability to step in, put the entities into a receivership, and address the systemic risk issue and hold people accountable, none of which will be present in the bankruptcy. In fact, I don't know how a bankruptcy judge reconciles the goals of bankruptcy against the goals of Title II of Dodd-Frank ever. And that's all about that. Thank you.
Marcus, there's a website called, a company called Open Corporates that provide, with which I have no connection, which provides some really compelling visualizations for corporate structures across borders. And you can go look up some of these banks here, and well, he's doing it now. And you can see the way in which they're connected, at least at the number of subsidiaries across jurisdictions. So you would need a treaty between all of these jurisdictions, all the significant ones, in order for this kind of bankruptcy procedure to work across borders. And other bankruptcy lawyers or other corporate lawyers who work with the big banks agree with me on this, including in public. So where's the treaty? If you have nothing, if you don't have a treaty, it's worth nothing. Get a treaty, and good luck with the treaty.
You either need a treaty or you need to flush massive amounts of cash down to the subsidiaries so that they are so obviously solvent nobody will worry about them, which starts to look like a disguised bailout, as Marcus talked about.
Okay, so let's open questions. Yeah, and I'll repeat your questions into the mic. So. Right here.
Stuart Rosenblatt, I work with EIR. They were great presentations.
Thank you.
My question actually is more a comment, and it would be on two things that I'd like to respond to. On October 21st, Tom Curry, who's controller of the currency, made a speech here in D.C. At the Exchequer Club, and he said, quote, "We are clearly reaching the point in the cycle where credit risk is moving to the forefront." And he cited a bunch of areas that are looking like 2008. He said home equity lines of credit, leveraged loans, subprime auto loans, which I think is about 1/3 of the loans, commercial real estate, and you could add, obviously, all of the turbulence in the commodity sector where there may be $5 trillion or more in derivatives that are in play. My question is, A, would you like to comment on that? And B, I've been in the middle, of this whole campaign around Glass-Steagall, and I know that Mr. Johnson raised it, and I'm curious to know what the panelists think, because Tom Honig did say it is imperative to act along this line in advance, and it's been raised in the Democratic debates and in Congress, and those are my questions.
Great. So the two questions, are we at a particularly dangerous point in the credit cycle? And what is the relevance of Glass-Steagall to some of the structural simplification issues in resolution?
I'll take a shot at the second one. I think I just sort of underlined something. I think it was Senator Brown who said that we shouldn't take the existing structure of large financial institutions as a given. And I think that's absolutely right. So that, you know, there's no, people say, well, Glass-Steagall is impossible now given JP Morgan Chase. But that's, again, only if you assume that the current structure is inevitable and is the way it must be.
Others?
Well, there's obviously a lot of pressure on very large financial institutions to become simpler. There's pressure from the market. Opacity is falling out of favor. I do think, though, the cyclical pressures often make people forget. And, you know, Mr. Curry's raising some good points, but it would not be a surprise if the cycle has further to run, particularly given where we are with regard to interest rates. So I think you don't know exactly what lies ahead, and you need to prepare, and you need to prepare on multiple fronts, including a lot more capital, much more equity funding. I think that's first and foremost, and I think complementary to that, and that's a regulation decision, as you know, primarily, because everything that we could imagine would be in Brown, but it could also be implemented in a way that completely consistent with Basel III by the Federal Reserve and others. But I think complementary to the regulatory action, it makes sense to propose legislation that would force simplification. I think it concentrates the mind and it gets the right kind of attention, and it helps regulatory resolve. I think you should want it all.
Okay, thank you.
My question is for Professor Johnson. What are the biggest barriers you see that would preclude collaboration within international regulators in case of another crisis? And number two, what are any feasible options that we have, since it appears that a treaty is off the table?
So the question was about the possibility for collaboration between international regulators and what options we have for that without a treaty.
Yes, I mean, so to be clear, there's two international issues. One is between courts in a bankruptcy Title I setting, and that's one is completely unachievable unless you have a treaty, and you're not going to have a treaty. So that's not going to work, right, with today's corporate structures. The cooperation across regulators, which is the wording that you use, that pertains more to Title II. So is there a cooperation that's feasible between, for example, the FDIC and some authorities in Europe that could be applied, and that would be less than a treaty, it could be, you know, unconspicuous, but a memorandum of understanding, for example. You know, I think having these things and attempting things and improving this conversation makes sense. That there was obviously a breakdown at many levels of regulatory and supervisory communication running up to it in September 2008. So I'm not saying that's a waste of time whatsoever. I am flagging for you that these authorities in Europe, and the law in which they operate, and the way they interpret it, and how they would regard the treatment of various kinds of assets and liabilities, for example, in a bankruptcy is not at all what you have in mind. The political pressures that they will face are not at all what you'd be comfortable with. And, you know, is there some probability that this kind of cooperation could work under some instances, for some scenarios? Sure. Is this what you want to rely on? Is this what's going to make you feel you've ended too big to fail? Absolutely not. No. Really don't go there. It's not attainable.
I'd like to add something briefly to that, which is most European bankruptcy regimes are much different than the United States bankruptcy regimes, and companies aren't expected to continue to operate. One of the biggest problems in the Lehman bankruptcy that Harvey Miller, who at Weil Gotshal expressed, was that the European side things went dark because they didn't even know where the assets were, the liabilities, or anything else at a time of terrible crisis. Everything went dark because the administrator came in and the companies ceased to operate in Europe. And I think those are kinds of very mechanical and obvious problems that just go to the heart of what Simon's saying.
Even between the United States and England, where you might think we have similar bankruptcy systems because they're both Commonwealth systems, there's massive differences. And then it gets even more extreme once you get over the continental approach.
The remark made, which is not quite public enough for me to use his name, but I can say it was from the Bank of England, former senior official, was that if you Americans are going to do Title I, the bankruptcy, all cooperation's off the table. The Bank of England will not be cooperating with a Title I bankruptcy proceeding in the United States. They'll be looking out for their own interests. They'll be pursuing the laws as they understand them in the UK. So, they're being honest, given that.
Okay. I think we have time for one more questions because the regulators have generously given us their time. As we've all heard, they have an impossible job, so I'm very glad they came here to share some time with us. But let's just ask one more question here. Sorry.
So,
Yeah.
continuing to focus on Europe for a little bit, how has the new Bank Recovery and Resolution Directive that the EC has passed, which now the national jurisdictions there are implementing into law, I mean, isn't that revamping entirely how the European countries look at bank resolution?
There are certainly changes afoot in Europe, but if you look at the way in which these rules and principles have been applied in the recent past, in terms of who they think should incur losses under what circumstances, very hard to see what the principles are coming out of this. If you look at the national level, right, so you're speaking about a European directive, as you know, it has to be implemented at the national level. There's a lot of problems, very real problems, that are becoming increasingly clear now in terms of the national implementation of all of these EU directives in this space, right? So there's not a consistent approach across countries. So are they trying to move are they recognizing the issue? Are they trying to move this in the right direction? I think to some extent for themselves and within the euro area, yes. But are they in a place where it would be easy to cooperate? There's a shared framework or a shared set of legal principles or operating principles or responses, policy responses, rules that are going to be applied in a crisis? No, absolutely not.
Could I just add briefly, I think the U.S. is somewhat unique and esoteric in some ways in trying to use normal bankruptcy as the first line of defense.
Yes.
Here. And so there may be a lot more avenues for coordination on the Title II front than there are on the normal bankruptcy.
Yeah, the Europeans, there's a set of things that you would not call a bailout. They would have other, perhaps, euphemisms for it. So their tolerance for what we would call bailouts is much, much higher. They have a different view of the state, right? Different view of the relationship between state and business, different view of what the state does with big banks. Most of them have a much less diverse financial system, so we have a lot of strength in our mid-tier and even in our community tier still. Most of them don't have that. If they have a mid-tier, it's a very weak mid-tier, like in Germany. So the attitude, that matters because it's ultimately the Ministry of Finance with the central banks. So the Ministry of Finance is going to call the shots on this. What are they willing to commit to? On what basis? Who are they protecting? How do they see domestic versus foreign? Very different attitudes from the United States and not converging whatsoever. And this is a big issue, for example, if you want to look ahead, the TTIP, for the US-Europe Free Trade Agreement. This is going to be a very salient and very difficult issue to get past. And when you talk to Treasury, and they say this on the record, they are not comfortable at the level of TTIP with the idea that we are substantially converging with the EU on regulation, that we should recognize EU regulation as being essentially equivalent to us. And that's just reflecting a different version of what I've been saying.
Okay, well, thanks very much to our panelists, and we're going to try to start our,